Welcome to Time is Not on Your Side with your host, board-certified litigation attorney Robert Eckard. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, roberteckardlaw.com. Now here's the host of Time is Not on Your Side, Rob Eckard.
Hey, welcome to Time is Not on Your Side podcast season 2. I'm your host, Robert Eckard, board certified business litigation attorney and government investigation specialist. In the last episode of Time is Not on Your Side, I gave you at least 12 instances where you should call your business lawyer, which leads me into today's episode. When ICE comes knocking, know your rights and what documents you should have readily available. The acronym ICE, it's an acronym that stands for the United States Immigration's Customs Enforcement Agency. ICE is a federal law enforcement agency under the United States Department of Homeland Security, also known as DHS. This was created by the United States President George W. Bush on November 25th, 2002. ICE's duties include, and then carried out through more than 400 federal statutes, and focus on immigration enforcement, preventing terrorism, and combating the illegal movement of people and goods. The November 5th, 2024 election of United States President Donald J. Trump, who was appointed a seasoned, experienced, and formidable cabinet, including United States Attorney General Pam Bondi, Border Czar Tom Homan, and DHS Secretary Kristi Noem, and the many executive orders now signed by President Trump, which just recently revoked the long-standing policy that prevented agents from going to certain sensitive areas, such as hospitals and schools, to locate and arrest criminals who are in the United States illegally. Given the wave of sophisticated criminal cartels that have made a mockery of the United States border protection laws under former President Joe Biden and his administration, the new sheriff in town, President Donald J. Trump, and his handpicked cabinet appointments will help secure our nation's border, thereby protecting the citizens of the United States, including the illegal importations of fentanyl and other massive quantities of illegal drugs and human trafficking, coordinated by bad actors from everywhere in the world who have made the United States their economic playground, causing irreparable harm to the United States, its citizens, and all other lawful status holders. The United States Constitution starts with the words, "We, the people of the United States." Like it or not, the United States Constitution and all of its guarantees and protections was and is intended to protect the people in the United States that are citizens, U.S. citizens, and otherwise lawfully residing, working, and otherwise visiting this great country. So what do I do if ICE or another law enforcement agency comes knocking at my door? Generally speaking, government law enforcement agencies are free to go any place your organization that the public may go. If you have a waiting room or a lobby and it's freely open to the public and they wish to enter it, I'm not aware of any valid argument that would prevent law enforcement from also entering. However, if you're a private business in which the public is not generally free to enter, that changes the analysis. If law enforcement has reasonable suspicion that a crime has been committed, they could detain people, determine if probable cause exists to make an arrest. Also, if they're executing on a judicial search warrant or arrest warrant, you should ask them politely to see the warrant, since they're obligated to show you the warrant. Do not interfere with their duties unless you want to be arrested. If there's going to be a challenge to the search warrant or the arrest warrant, now is not the time to do it. The time to challenge or dispute the warrant will be in front of a judge at a later date, with the prosecution also present. However, you may ask for a copy of the warrant, be it a search warrant or an arrest warrant. The search warrant is the only document that will give law enforcement the right to engage in a search of private property. And that search warrant must have been signed by a judge within a reasonable time of its execution, specifically identifying the property to be searched and what the search is for. An arrest warrant, on the other hand, authorizes law enforcement to arrest the person specifically identified in the warrant, but it does not authorize them to enter private property to execute and seize upon the person, unless they are granted or specific consent or permission by the property owner or tenant. Basically, the arrest warrant allows the police to arrest the person once the police encounters them, but it does not compel anyone to allow a search of the premises. If ICE has a search warrant that specifically identifies your location, they get in. If they have an arrest warrant without your permission to enter, they can't get in. ICE agents and all government agents must respect the limitations imposed upon them. However, you may find in some situations that some law enforcement agents believe that using threats or bullying will permit them to get whatever they want. This is not the norm, but there is no bright line test for this. However, you have the right under most circumstances to record interactions with ICE officials, take photos of what is taken, and make a record of the events of that particular encounter. But don't get in the way. As long as you are not physically interfering or obstructing with law enforcement, you have a right to memorialize the agent's activities. There are times when law enforcement agents get mad at being recorded and may threaten to arrest you for obstructing justice. Courts have consistently rejected those types of charges. I've personally been involved in cases like this, and while the arrest, being transported to jail, being booked into jail, and waiting in a holding cell until your first appearance before a judge is not a pleasant experience, the charges have been ultimately dismissed. Immigration policy is complicated. With the uptick in enforcement of our nation's border laws and increased arrests by ICE agents and their counterparts of dangerous criminals who have freely entered the United States over the last 4 years, it's unfortunate but inevitable that there will be collateral damage to families and loved ones of these illegal people. However, this is not something new, as there has often been collateral damage to families and loved ones and occurs in some of the most basic domestic crimes. On February 5th, 2025, Attorney General Pam Bondi issued a series of internal memoranda directing the Department of Justice to implement policy priorities of the Trump administration. Several of these directives touched on immigration enforcement, including restrictions on Department of Justice funding for states or cities that do not cooperate with federal immigration enforcement activities, sometimes called sanctuary cities. This high enforcement environment impacts all employers. For example, the Department of Justice is instructed to authorize enforcement of federal statutes that impose criminal penalties for hiring, continuing to employ individuals without lawful U.S. work authorization. Preparedness is the key. Now is the time for employers to review their risk profiles based upon their industry, hiring practices, and employee population, and to take affirmative steps to ensure compliance with all applicable immigration requirements. So I put together a list of 5 key questions that should be asked to assess an employer's risk profile. Number 1, is your business prepared? An immigration-related worksite enforcement and investigation intensifies. Employers must adopt proactive strategies to prepare for audits, unannounced site visits, raids, and other compliance challenges in the advance of government worksite involvement. The employer should take all reasonable care to verify employees' identities, ensure that they're authorized to work in the United States in accordance with Form I-9, also known as Employment Eligibility Verification Procedures. This includes proper training of all individuals involved in recruiting, screening, hiring, onboarding, and verifying employees to ensure compliance with work authorization requirements. Employers must also be careful to avoid discrimination based on citizenship or national origin. For example, by requesting more or different documentation than is required for completion of the Form I-9 process. Number 2, are your employees prepared? Employees should ensure that they maintain proper documentation of their valid identity and work authorization status at all times. Employees should review, download, and print the electronic I-94 entry record as soon as possible after each U.S. entry and immediately seek corrections through various custom border protection deferred inspection if required. Employees must be diligent in reporting any change in their U.S. residential address to U.S. Citizenship and Immigration, also known as USCIS, within 10 days of moving by completing Form AR-11, which can be completed online. Number 3, has your business conducted an independent external audit of its workforce employment authorization verification within the past year? In addition to regular internal audits conducted by employers for verification, the environment depends upon external review by independent professionals with the experience necessary to identify potential weaknesses and deal with potential violations. 4, does your business have a plan in case of a government site visit or raid? Federal authorities may make an unannounced site visit, and employers should prepare a set of standard operating procedures for receiving government officials if and when they arrive. The standard operating procedures should include guidance from the designated response team. For example, the receptionist, human resources, the IT staff, in-house counsel, or other leadership of the company, with instructions for verifying the identity of the federal officers, a designated space for audit activities, location of files to be pulled, and specific list of the documents the company is prepared to share. In addition, employees should be advised in advance of the business protocol. The standard operating procedure should anticipate government visits at sites outside the corporate headquarters or major work sites and plan accordingly. The goal is to ensure all decision makers are apprised and ready according to established communication channels, and not to create panic that could impede the employer's plan for resolution of an investigation or audit. 5, do you work with outside counsel that has experience not only on immigration compliance, but also on immigration-related investigations, litigation, and media crisis management? Expanding enforcement by DHS and the United States Attorney's offices carries the potential to disrupt continuity and disrupt the ability of employees to continue to operate. Additionally, continuing to conduct business in the midst of an investigation brings particular challenges. Therefore, businesses are well advised to engage outside counsel who has a thorough knowledge of immigration compliance, investigatory matters, and reputational risk management. Businesses must be prepared to respond quickly to allegations of immigration violations in aggressive investigations by DHS, federal prosecutors, the Department of Justice, and related agencies. Experience with working with law enforcement agencies and federal prosecutors is critical to an employer's ability to withstand federal scrutiny of the employment practices. What's Florida's role been in this? On February 13th, 2025, Florida Governor Ron DeSantis signed 2 bills into law related to immigration, Senate Bill 2C and Senate Bill 4C, which were based upon and enacted based upon Senate Bill 171B, aimed at assisting immigration enforcement activities put forth by President Trump. One law creates immigration-related state crimes and enhanced penalties. These changes include making it a crime for adults to knowingly enter the state illegally or attempt to do so. Voting by undocumented immigrants is a third-degree felony under our new legislation. Another measure that imposes the death penalty for any undocumented immigrant convicted of a capital felony in Florida. The law also increases penalties for all misdemeanor crimes committed by undocumented immigrants. The second law focuses on students. Undocumented immigrants will no longer be eligible for in-state tuition at public colleges and universities beginning in July of this year, 2025. Students will be reevaluated for tuition classification. Under these laws, approximately $300 million is allocated to state law enforcement agencies for their implementation of Florida's immigration priorities. A portion of these funds will go to additional law enforcement officers, and there's a $1,000 incentive bonus to officers participating in these operations. This concludes another episode of Time is Not on Your Side. Be sure to hit the like button on your social media platforms and drop me a message if you have any questions or comments.
You've been tuning into Time is Not on Your Side with your host, board-certified litigation attorney, Robert Eckard. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, roberteckardlaw.com. Thank you for your positive reviews, comments, questions, and for sharing this show with others.